determine whether the acts of the executive and the legislative branches are null because they were undertaken with grave abuse of discretion. End of quote. A harmonious blend of courtesy and caution. Hanggang ngayon, pilit ko pang hinahanap ang sinasabing courtesy and caution na dapat nagpaalala sa ating Korte Suprema sa pagsulat ng desisyon nila sa Duterte versus HOR. We respect the judiciary. As a lawyer, I respect the judiciary. But respect must be mutual. The court must also honor the legislature's exclusive domain over impeachment unless there is clear, grave abuse of discretion or blatant violation of the Constitution, which this House most certainly did not commit. Upholding the Constitution sometimes mean checking a co-equal's overreach. In this case, it is our duty to call out the Supreme Court's encroachment on Congress's power done under the guise of procedure. Sa botohan sa Senado noong nakaraang Miyerkules, halos nag-chorus ang mga anti-impeachment na senador sa pagsasabing kailangang igalang desisyon ng Supreme Court. Pero mula pa noong Pebrero, sino ba talagang hindi gumalang sa mga institusyon ng gobyerno? Sino bang sinabihan ng Senate President na mali yung timing ng pag-transmit ng articles of impeachment dahil tapos na ang session at mangangampanya na ang mga senador? Sino bang inutusan ng Senado na mag-certify na hindi lumabag sa one-year bar rule ang House at niremand dito ang articles of impeachment? Sino ba ang tinanong ng Korte Suprema kung nabasa at naintindihan ba ng mga House members ang articles of impeachment na kanilang pinirmahan? Sino? Matapos ang napakahabang proseso sa Senado at sa Korte Suprema, ang hindi man lamang binigyan ng pagkakataon na mag-oral arguments bilang isang co-equal branch bago isulat ang desisyon. Kung respeto lang po ang pinag-uusapan, nilunok na ng mga miyembro ng kapulungang ito ang lahat ng kanilang pride para lamang irespeto ang Senado at Korte Suprema sa kabila ng lahat ng pag-iinsulto na ginawa sa kanila. Records clearly show that the impeachment was duly initiated in February 5, 2025, in full accordance with Article 11, Section 3, Subparagraph 4, and yet the Senate failed to do its duty to proceed with impeachment forthwith. The Senate could have convened as an impeachment court as early as February or March, but it did not. Some of us in the House grew concerned at this 5-month delay, as justice delayed is justice denied. Still, the House prepared for trial, designating our House prosecution team and readying our evidence. Nevertheless, on June 10, in a twist, the Senate adopted a resolution to remand the articles of impeachment back to the House, asking the House to certify that the one-year bar rule had been observed effectively. The Senate was suspending the trial pending this certification. Alas, on July 25, without any oral arguments, the Supreme Court issued its decision nullifying the House's articles of impeachment and barred the Senate from proceeding, supposedly on the ground the impeachment was initiated more than once in a year and that the Vice President's due process rights were supposedly violated at the House level. Worse, even if the House of Representatives, through the Office of the Solicitor General, filed a motion for reconsideration, the Senate, in plenary session, voted 19-5 to archive the impeachment complaint against VP Duterte. This move was exceptionally swift, contrary to their extremely tardy action, their stalling when it came to their convening as an impeachment court. Aside from the House's motion for reconsideration, 4 other MRs were filed by movements interveners. The first group of complainants with the endorser, Akbayan Representative Percy Sendanya, Isang Bayan and the Makabayan Bloc, and just yesterday, another group of interveners, the third group of impeachment complainants, also made a plea to the court to reverse its July 25 decision. These MRs are not frivolous or sham. They raise strong and compelling arguments necessitating a serious review of the July 25 decision. At sana po, sa pagkakataong ito, magpatawag ang Korte Suprema ng oral arguments. The pending motions for reconsideration embody the Filipino people's concern for the integrity of the impeachment process and their call for the accountability of the Vice President. To ignore these legitimate pleas by archiving the articles of impeachment even before they're fully heard by the Supreme Court is being insensitive not only to the demands of the lawmakers, constituents, and sectors they represent, but to public opinion as well. The Senate has not even started the trial, but it moved with lightning speed to bury the complaint once the Supreme Court gave them an opening. The Senate dragged its feet on the actual impeachment trial, but moved immediately when it came to archiving the complaint. Parang mali po yata ang intindi nila sa forthwith proceed. Forthwith apparently was observed in the breach. Ang bilis nilang kumilos pagdating sa pagsasara ng kaso, pero napakabagal nang sila hinihilingang dinggin ang kaso. If this is not a case of double standard, I don't know what it is. The irony is that following the decision of the Supreme Court in Duterte, archiving the articles of impeachment is tantamount to a dismissal. Hindi po ba yun ang sinasabi, yung first three complaints daw, when archived, were deemed or effectively terminated or dismissed? Some senators have said their preemptive vote was simply respect for the Supreme Court. But let us be honest. It is the House of Representatives whose constitutional prerogative has been disrespected. The Constitution commands the Senate to proceed with impeachment forthwith, yet it took them nearly half a year to even consider convening as an impeachment court. But when the opportunity came to archive the complaint, suddenly forthwith was crystal clear to them. That burst of urgency after months of delay is telling. It is not unreasonable to suspect that this timing was no coincidence, that the Senate's slow walk at the start bought time for the Vice President, for her lawyers to reach the Supreme Court, and for the court to run the full length of its decision-making ritual. This was not respect for another branch. It was a choreography of convenience, and the House was the one made to bow. Those are the facts, Mr. Speaker, Madam Speaker, and dear colleagues. Maliwanag na maliwanag po na sinunod ng Kamara ang proseso at ang saligang batas, at hindi po ang House ang lumabag nito. If anything, it is the Senate whose unorthodox actions need defending before the bar of public opinion and when posterity will take a look at this chapter of our history. I have great respect for the Senate as an institution, having had the privilege of serving one of its former members. And I know there are senators, those who voted against archiving, for instance, who also see this